Excellent. Okay, first of all, special education law. Where does it come from? You've got a federal statute, and each state has state level laws, and then you have fair hearings. Now, the federal law trumps everything. States can come in and they can be more restrictive, but they can't be less restrictive when it comes to special education law. For example, the federal law says that you have 60 days to assess a student from the date of the assessment plan is received by the district. Now, before we go on, let's talk about that. The date the parent signs the assessment plan is not when the 60-day timeline starts. It's the date that the district receives the assessment plan. If your district receives an assessment plan and they do not mark on it the date that it was received, then the date the parent signed it is considered the start date. So it is very important, all the secretaries at all your school sites know that when they get that assessment plan, they indicate the date it was received, because that starts your 60-day timeline. That being said, if that secretary then puts it in a routing folder to the special education department at the district office, and that takes 4 or 5 days, and then the secretary at the special education office puts it in a routing folder to you, your timeline is running. So hopefully your SAI teachers, if they send out the assessment plan, they have a process for getting it back in a timely manner or being informed right away. All right, we got sidetracked already. So the federal law gives you 60 days to assess a child. Now in California, our law is more restrictive. We have 60 days to assess and hold an IEP meeting. That's perfectly legal, and we are bound by that. Now, let's talk due process or fair hearings. Fair hearings what will happen is a parent will take a district to court, and the judge will hear the case and make a ruling. Every district out there will then change their entire special education policy based on that ruling. Due process and fair hearings do not establish precedents like normal court cases do. In special education, every court case is considered to be unique and individualized. So try to train your districts not to overreact to a fair hearing, because the exact same scenario presented with another student is considered to be totally unique to that student. But it does give us an idea of, as I say here, the zeitgeist or the current cultural temperature of the special education climate out there. That's what fair hearings do. And you can subscribe to a listserv that will send you the summaries of all the special education cases held every month. These are summaries that go through exactly what the parent was charging the district with, the parent's evidence, the district's evidence, all the discussions, and then the ruling. And the rulings are important, and they're interesting because the judge backs up every one of his or her rulings with case law, and they'll reference cases. And that's where this presentation came from. As I started reading these cases, I realized there's only like 15 cases that keep coming up over and over again. 15 cases that districts keep ignoring or handling wrong. And so That's where these came from.